Good morning. May I reserve 5 minutes for rebuttal, please?
Yes.
May it please the court, Mark Donahoe on behalf of Ricky Allen. At 11:12 p.m. on the night of September 16 of 2021, Ricky Allen was stopped in a traffic stop. Officers approach, they return to their patrol car, and for 18 minutes, nothing happens. 18 minutes later, the officers returned Mr. Allen and they asked him to exit the vehicle at that point. This is Officer Hughley. He's not a rookie. He has alcohol training, DUI training, knows how to administer field sobriety tests. And interestingly, he does not know Ricky Allen, who's also a member of the Jackson Police Department. And not only did he not know him, but he didn't know anything about him. He admitted at trial there was no conflict. He treated it like a normal investigation. But for some reason, he called in other officers. The sergeant arrives, and eventually we get a lieutenant on scene, and eventually we get more and more people on scene. It's interesting to note that during the 17 or 18 minutes that Mr. Allen was still in his car, he was left in control of the car, full physical control, and then Sergeant Wright, who's important in this case, arrives on the scene. And Sergeant Wright, he doesn't recuse himself. He begins to investigate. He starts asking questions. He started asking Ricky questions about where he'd been, what he'd been doing, what had happened. Ask him to take field sobriety tests. And this is a point that we think is important in that Mr. Allen at that point declined to take the field sobriety test. Now, at this point, when you decline to answer questions and you decline the field sobriety test, it's, in a normal case, which what this should have been, in a normal case, a police officer has to make a determination at this point. Are we going to arrest or are we going to let him go, based on what I know right now? And at that point, all the officer knew at that time, remember, the sergeant that's on scene did not make the initial stop. He only knows what this officer has told him and what he has observed. That's the total that he knows. At this point, something should have happened, but nothing happens.
Mr. Donahoe, when we look at the record, it was referred to in the brief, but I think it was Officer Hughley was recorded on either the dash cam or the body cam speaking to somebody on the phone relating he's drunk or he's talking to somebody either on the scene or on the phone saying that Mr. Allen was drunk. When was that?
Hughley makes different statements at different times during the investigation. Early on, he did make that statement, but if you look at Hughley's, where he also says on the video that, and during questioning at trial, where he didn't notice, he says specifically, I did not smell alcohol. He says, there's no notation, he didn't testify about in noting anything like bloodshot eyes or slurred speech or anything like that, nothing like that. And I questioned him about that. And he had none of those observations. So the total amount of what Hughley knew at the time of the stop was that he had observed driving that potentially could be a DUI, that he testified he had used that because of his experience in seeing and making stops previously. And we all know that sometimes those stops are justified and sometimes they're not. But in this case, that was the total amount of what was known when the sergeant got there. That's what Hughley knew. Remember, Hughley didn't conduct any investigation with regard to a request for field sobriety. That was done by the sergeant. So all the sergeant knows is what he's been told about the driving and when he starts the question, Mr. Allen says, not really answering any questions. He said, I'm not taking a field sobriety test. And that's where we are.
And at what point did Mr. Allen hand over his JPD identification?
That would have been in the initial stage when it was approached to begin with, at the very beginning, when Hughley first approached the car. That was a testimony, if I'm remembering that accurately.
Yeah,
That was a testimony at trial.
I believe, even though you said Mr. Hughley didn't know Mr. Allen from the...
That's correct, sir.
He was aware, he saw a jacket in the car and he saw his ID.
That is correct. It was, I'm sorry, I didn't mean
No,
to
that's okay, and that's...
insinuate.
So he was, at the very beginning of this encounter, was aware that there was this issue?
Yes, sir. No question that he was aware that Mr. Allen was a either had been or is a police officer. He just didn't know him personally and had no interaction with him or know anything about him at the time, which we think is important in that the state at some point has raised the fact that there's a potential conflict, and there's not. There's never been. There's no policy. There's not anything to say that we can't. As a matter of fact, I questioned officers at trial, numerous, all of them. Is there any reason Ricky Allen as a police officer should be treated differently? Is there, and every one of them said no. Is there any reason that you could not have conducted a field sobriety test on scene? No. Everyone. And the important part of this also is Lieutenant Story, who gets there. He comes in at 11:32, which is 20 minutes later. Lieutenant Story is an instructor. I questioned him about that. He's a DUI instructor for DUI enforcement for JPD. He testified he could have done the test, but they didn't. And here's another part. They called THP. THP, Faison arrives, 12:05. But it's interesting, if you look at the video, Faison doesn't immediately go into an investigation. If she's called in to be an independent investigator, why doesn't she go immediately to Ricky Allen and begin a typical investigation? That doesn't happen. From 12:05 until 12:37, for 32 minutes, she's talking to the JPD officers, and they're telling her what they think, instead of her doing this so-called independent investigation. She speaks with Allen at 12:37, begins the field sobriety at 12:38, ends at 12:46. He is placed under arrest and read, and here's another interesting part. From 12:46 until 1:09, nothing happens. She's talking to her sergeant. And at 1:09, Mr. Allen is arrested and read Miranda warning, placed in the vehicle. So, which is from 11:12 to 1:09, 11:12 time of the stop to 1:09, 2 minutes prior, or 3 minutes prior to a 2-hour window, which is, our position is unconstitutionally long, too long.
In the initial, I think you said 18 minutes.
Yes, sir.
From the time Officer Hughley made the stop until, I guess, Sergeant Wright arrived, or what does the record show Officer Hughley did or said concerning this stop? Is that recorded? Is he mic'd when he's on this, whoever he's talking to?
It was not a significant issue at trial. Basically, he didn't do anything other than call other officers. He called Officer Michael, who didn't testify at trial for some reason. He then called the sergeant, who did come at some point and basically took over. And then I apologize to the court, I don't recall if he called Lieutenant Story. I think the sergeant called Lieutenant Story, is I think the way that sequenced. And then Story called the chief of police at some point, and then Story called THP, I believe.
But at some point during that 18 minutes, Officer Hughley can be heard to say that Mr. Allen or Officer Allen was drunk. Is that?
But but we don't know. He says that on video. He didn't testify to that at trial, as I recall. There was no basis for that other than his observation of the driving, because the video also confirms, along with his testimony at trial, he says, I didn't smell alcohol. And there's no notation, he made no testimony like, I saw bloodshot eyes, or I saw staggering. And if you look at the video, when he finally asked Ricky Allen to get out of the truck, he gets out, there's no, I would submit to the court, there's no sign of DUI when he gets out of the vehicle. He's not stumbling, he's walking, he's talking, you can hear him talking. There are no issues or shows, nothing to show that at the time. And as I recall, and I don't recall if I questioned Hughley extensively about this because he had such little involvement other than the initial stop, but the other officers testified that field sobriety tests are necessary in order to really make a determination as to whether or not a person is under the influence. We do them in every case, or we do them almost in every case, except in the ones where they're denied or the person denies it, and then lots of times they're placed under arrest for the implied consent violation, which we know in this case there was a violation because it was not read properly. The court issued an order earlier requesting, the court issued an order that said that part was not admissible, that you couldn't admit the fact that he had denied the request. It was Officer Faison at that time, but you'll recall earlier, when the sergeant asked him to do the field sobriety, he declined. They didn't read him the implied consent form at that time. Why, I don't know, but they didn't. They should have, but they didn't.
You know, we usually see extended detention cases concerning a drug dog being
Yes, sir.
brought to the scene because the officer has a reasonable suspicion. Did you find any cases that were DUI cases that involved extended detention?
No, sir, not that. The closest thing we found was the case we cite, the United States v. Place. Now, it's a case involving where there was a detention at the airport. You know, in most of the drug cases, you have a stop for this issue, and then we also want to investigate this other issue. Place is not that way. The detention was specifically because they had probable cause to search, or wanted to have, had reasonable suspicion to search his luggage. He was detained, and the issue was they weren't able to obtain a warrant for 90 minutes. And the U.S. Supreme Court in that case said, and they weren't in that case going to a different issue, like a stop, and then let's do a drug investigation. They were a drug investigation from the beginning and focused on the drug investigation. It never changed. The Supreme Court said 90 minutes is just too long for that one specific incident, which is the same thing we have here. One specific incident that lasted not 90 minutes, but 2 hours.
So is it your argument, Mr. Donahoe, that the only evidence up until the field sobriety tests, the only evidence potentially that he was drunk was a driving pattern?
Not exactly, Your Honor. The other officers made some observations, apparently. But again, that contradicts what the video evidence shows, and it contradicts what Hughley said. Sergeant says one thing, Hughley says exactly the opposite. So probable cause determinations are highly fact specific. So if you contrast those two, then it doesn't mesh or jive. So, but then we think more importantly, when he declined to take the field sobriety test, at that point, the stop's done. He's not asking questions, he's not taking field sobriety. What are you going to do? Well, in a normal case, not involving Ricky Allen as a police officer, I know what happens. He's either going home or he's going to jail. And that's what should have happened here. My time is up for the beginning.
All right, thank you, Mr. Donahoe. All right, Mr. Coleman?
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state, filling in for Katie Neff, who has left our office for greener pastures. This court should affirm the judgments because the trial court properly denied suppression and also because it properly exercised its discretion in finding that the defendant had opened the door. Unless this court has questions with that, it seems that the defendant has relied on brief, and the state will also rest on its brief. But turning to the suppression, I think there was a statement my friend on the other side made today that we are in complete agreement of. When the defendant refused the field sobriety tests, the stop is done. And that's what happened here. The defendant was effectively placed under arrest at that point, given the totality of the circumstances and all of the information that the officers knew. Because he was not detained for an unreasonably long time, suppression was not warranted. Now, while there was logistic and administrative concerns and questions after that fact, the point is he was placed under arrest within 20 minutes of when he was pulled over. And at that time, the information that the officers knew that objectively allowed for an arrest that established probable cause was that at 11 p.m. the defendant was driving with his headlights off, that he was swerving lanes and going in and out of his lane, that he had difficulty making turns. Then when Sergeant Wright appeared, to your question, Judge Wilson, I'm not entirely sure. I haven't had the chance to go through every single video. I think Officer Hughley's comment that he's drunk happened in the while he was trying to get a supervisor on the scene, but the record will be more accurate. But possibly we have one officer's observation that the defendant is drunk. When Sergeant Wright comes, we certainly have more observations. Sergeant Wright smelled the odor of alcohol on the defendant. The defendant admitted to him that he had a few drinks, even though he refused to say how many. And then Sergeant Wright testified that he was abundantly familiar with the defendant, that they were friends, that they golfed on a regular basis, and based on his observations and his familiarity with this individual, Sergeant Wright opined that the defendant was sloppy effing drunk. At that point, and then again, the defendant was asked to do field sobriety tests and refused. At that point, he was placed under arrest. Sergeant Wright testified that he was not free to go. In fact, his physical movement was restrained because he wasn't even allowed to sit down. At that point, officers exercised physical restraint of the defendant, even if they didn't place him in handcuffs, and an objective person or an innocent person would not feel that they were free to go because the defendant wasn't. Those are the only two requirements to effectuate an arrest. Because the defendant was under arrest within 20 minutes of the stop, this complaint about this prolonged detention just doesn't hold merit. But even if this court, wanted to disagree and say that, okay, there was a prolonged detention and he wasn't actually under arrest, it was reasonable to further the investigation in a way that prevented any appearance of bias. Even if there wasn't an actual conflict, the officers did what was reasonable here and wanted to get an independent agency to come and review this to prevent even the appearance of bias. And that makes sense given how even when the officers testified, we wouldn't treat him any differently and this wouldn't affect us in any way of changing how we would address the stop, it did. Because Sergeant Wright testified that they were friends, that they went golfing. The lieutenant who showed up tried to persuade the defendant to agree and to do these things. Officers, instead of towing his car and subjecting him to a monetary fee, agreed, yeah, we'll just drive this back to your house, which is not a common thing. Throughout this interaction, there were threads that hinted that there might be an appearance of bias. So it's reasonable for officers to say, we want to nip that in the bud. We want to make sure that this is by the book and that everyone knows it's by the book. So we're going to call an independent agency. That's what they did. That was a reasonable basis to prolong the stop, if they in fact did prolong the stop. Unless this court has the questions, we respectfully ask that you affirm and find that suppression was not warranted where there was an arrest within a reasonable time of the stop or where any prolonged detention was reasonable and warranted.
Let me just ask, exactly at what point are you saying that the defendant was effectively placed under arrest?
Sometime between 11:30 and 11:32. The lieutenant shows up at 11:32. Before then, and I think Sergeant Wright testifies it's roughly around 11:30, he said that the defendant was not free to go. And again, while they're waiting on other things, the defendant was placed under physical restraint. So at that point, they have probable cause for all the reasons I've mentioned, and he is effectively placed under arrest. Even if the officers don't think it's an arrest, and even if it's, not necessarily the textbook TV version of putting you in handcuffs, reading you implied consent, reading you Miranda, the only requirements for it to rise from a detention to an arrest are that an innocent person would not feel free to go and that you restrain their physical movement. Those were here.
Okay, so did Officer Hughley, in the state's opinion, ever effectively place the defendant under arrest?
I don't think Officer Hughley did.
So that was a detention until Sergeant Wright arrived?
While Officer Hughley was calling for backup, trying to figure out what we should do, and that's a reasonable time to continue investigating the stop. Again, there's the comment, he's drunk. There's, as soon as Officer Hughley pulled up and walked up to the defendant, he saw a police jacket, and the defendant immediately handed him his police ID. So, okay, is he trying to get out? This is a little bit sketchy. I'm going to call for backup. I'm going to call, a fellow officer. I'm going to call my sergeant. Let's get some help out here. That's reasonable. Again, we ask that this court affirm the judgments. Thank you.
Thank you, Mr. Coleman. All right, Mr. Donahue, rebuttal.
It's interesting, Your Honor, that's the first time I've ever heard that from the state. At the trial, at the suppression hearing, they took the exact opposite position, that there was no arrest, and that Trooper Faison was called to determine whether or not he was intoxicated. That was the position they took at the suppression hearing. If I'd have known there was an arrest 20 minutes in, I would have been filing all kinds of motions to suppress statements, videos, and everything else that we weren't privy to, or I didn't have a need to, based on the fact that they took the position that it was Faison's job to make a determination as to whether or not he was intoxicated. And I note that during this entire time, after he's refused to take the field sobriety test, Lieutenant Story, who he knows, is talking to him on the videos numerous times. Well, if you go ahead and take the test, it's probably be in your favor. Then you can, if you pass, you can go home. He's talking him into doing it after he's already refused it an hour and a half down the road. So why are they trying to gather more evidence if they already have enough? It doesn't make any sense to take that position. It's objectively unreasonable here. And the objective standard, it's not subjective, what the officers thought or what they did, it's what they did. The objective, and this whole scenario is objectively unreasonable. There is no conflict, no actual recusal, there's no need for backup, there's no need for additional expertise, no evidence of a policy mandating it. Mr. Allen had declined to answer questions and take field sobriety tests. The delay and detention were objectively unreasonable, thus unconstitutional. Does the court have any further questions of me?
So when we reviewed the record, the state never made the argument there was an effective arrest before the trooper showed up. Is that what you're saying?
At the suppression hearing, the state took the position that there was no arrest made because we called in an independent person to do this to make the determination. That's the determination. And I questioned every officer at trial. Could you have done the field sobriety test? Would that have given you a basis to arrest? Would you have been able to arrest? You would have been able to do them. Yes, I could have done them if I had chosen to, but you chose not to. You were waiting on somebody else.
But on the opposite, I guess, did any of the officers testify that we would have had to cut him loose before the troopers showed up?
Would have had to cut.
Did they say we would have had to let him drive off?
Maybe I'm not completely understanding Your Honor's question, but no, there was no testimony that said he was able to leave or able to go or anything like that. They had him, he was out of the car, he wasn't allowed to sit down. He was leaning against the car and was in that position generally for the entire time. If that answers the court's questions, and I'm not sure it did.
You did.
All right.
Very good.
Thank you, Mr. Donahue.
Thank you very much. I appreciate the opportunity to be here again.
All right, thank you for your fine arguments. We'll take this case under advisement. Call the next case, please.
State of Tennessee versus Jason A. McCain.